Have you ever wondered how some employees negotiate better pay, hours, or benefits? It's not luck, it's collective bargaining. And if you're an employee, unionized or not, this is something you need to understand. Collective bargaining is the process where employees, usually through a union, negotiate with their employer over the terms of employment. That means pay, hours, working conditions, and more. Instead of going it alone, you're negotiating as a group with strength in numbers. You'll typically see collective bargaining in unionized environments like public education, healthcare, manufacturing, or transportation. But even if you're not in a union, understanding how it works gives you insight into how your rights can be protected or possibly overlooked. A collective bargaining agreement, or CBA, is a legally binding contract between the union and your employer. It spells out wages, work hours, job duties, disciplinary rules, even how grievances are handled. And once it's signed, both sides are legally bound to follow it. Let's talk about your rights under a CBA. Here are a few you should know about. First, union representation. You have the right to bring a union rep into any meeting that could lead to discipline. These are your Weingarten rights from the 1975 Supreme Court NLRB versus Weingarten. Next is the grievance process. CBAs usually have a formal process for complaints if your rights are violated. You don't go straight to court, you follow this process first. You also have a protection from retaliation. Your employer can't retaliate against you for union activity. That's protected under the National Labor Relations Act, or NLRA. And finally, you have the right to strike. Private sector employees may have the right to strike, though there are exceptions, and public sector workers often face limits. Collective bargaining is protected by federal law called the National Labor Relations Act of 1935. This law guarantees your right to organize and negotiate as a group. And here are a few court cases that help define your rights. Weingarten, 1975, the right to union representation in investigations. NLRB versus Katz, 1962, your employer can't change terms without negotiating. Lechmere versus NLRB, 1992, limits union access to private property. Janus versus AFSCME, 2018, public workers can't be forced to pay union dues. Don't tune out if you're not in a union. You still have rights under Section 7 of the NLRA. If you and your coworkers talk about pay or working conditions, that's called protected concerted activity, and it's legal with or without a union. Collective bargaining is more than a contract. It's about fairness and empowerment in the workplace. If you're in a union, know what's in your CBA. If you're not, know that you still have rights when you speak up together. And if you're facing issues at work, especially related to union representation or retaliation, talk to an employment lawyer who can help. You can visit SpiggleLaw.com to book a consultation with our firm today. We also have a free online community for employees facing workplace issues. There you can ask questions for our employment attorneys, interact with other members' posts, and more. Visit SpiggleLaw.com/community to join for free.